HCMC stock update today, a summary of the reply in support of its motion for leave to file an amended complaint. Number one, HCMC's amended complaint alleges facts confirming that PMI's accused IQOS device initiates a combustion reaction and thus infringes the 170 patent. Number two, PMI's opposition to HCMC's motion attempts to implore the court to undertake claim construction at this early stage, the pleading stage, which is premature and inappropriate according to HCMC. The proper construction of a combustion reaction in the context of the 170 patent, because that is the premise of this allegation, the 170 patent. And this case is a question of law according to HCMC and premature at this point. Number four, HCMC's amendment in its complaint is not futile. Therefore, not only does HCMC's amended complaint state a claim to relief that is plausible on its face, but is also supported by a declaration of Dr. Michael Deible, who goes above and beyond pleading the requirements by providing test results confirming that the IQOS system initiates a combustion reaction consistent with HCMC's allegations set forth in the original complaint. So HCMC cited a case law, that is the case law as it concerns Deible and Deible. And that case law states that to survive a motion to dismiss a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. So to a great extent, HCMC has provided a factual matter, which is largely that experiment conducted by Dr. Michael Deible. Number five, HCMC's allegation in the amended complaint are consistent with the original complaint and the intrinsic evidence of the 170 patent. HCMC's allegation that the IQOS system initiates combustion reaction are consistent with those set forth in the original complaint. The only difference is that the only difference is that the allegation are now supported by HCMC's testing, as explained by Dr. Michael Deible, rather than PMI's FDA submission that the IQOS generates markers indicating combustion. So you all know that that was why that initial complaint was dismissed. So the asserted claims of the 170 patent require initiating a combustion reaction, and we know that experimentally that the IQOS system has combusts based on experimentally. So number six, PMI's futility argument is at best premature because it is a non-infringement argument requiring claim construction here. So we have touched a bit about this. So what is more, PMI considered that a proper construction of the combustion reaction underlies the dispute between the two parties, that is between HCMC and PMI herself, and therefore consideration of PMI statements to FDA raises issues of claim construction that is not appropriate at this stage. That is what HCMC is alleging. So number seven, HCMC's allegation in the amended complaint are not contradicted by PMI statements to FDA, which are no longer part of the record in this proceeding, in this motion to amend. So HCMC's original complaint was dismissed based on the court's finding that HCMC's allegations were contradicted by PMI statement to the FDA. We all know that. So while PMI's FDA submission is no longer part of the record before the court, the allegations set forth in HCMC's amended complaints are in no way contradicted by PMI's statement to the FDA. So number 8 and the final is that PMI refused to address the baseless accusations against HCMC, its principals and its attorneys. So HCMC did not go further to substantiate all those allegations about securities fraud and all that stuff, including the fact that you and I are unsophisticated investors and all that stuff. So expect more videos concerning the prospects of this case and where we're going next. Thank you very much for watching this video.